Greetings. I hope you guys are doing well today. Let me see something real quick. I'm going to see. I think I have found my microphone, which will help you guys be able to hear me, because what I'm going to explain to you is very important. And I have not necessarily made mistakes in the past, but I know there's something more to the procedures that are going on in these administrative, quasi-judicial, in rem proceedings. All right, that's what they are. Absent a grand jury indictment or an actual victim, you are not in a judiciary. You are in a quasi in rem, which deals with things, not men, proceeding. And my brother Mark, over the last couple days, has been showing me some things that he has shown me in the past, and I just overlooked them because I was looking at the securities, the rights, titles, and interest. I was looking at the equitable side of things. And he goes to really help people like you want to do. Maybe the best way to help them is to show them how simplistic it is to destroy these at-law, in-rem, ministerial administrators and their quasi-judicial proceedings. That would probably be the best thing you could do, Derek, because you're very learned, and I understand what you're doing and why you're doing it. But to help the masses, perhaps you should articulate how simple it really is. You see, although you may be on this earth and in this world, you are not of this earth, and you are definitely do not belong to the world. You're a living, sentient being. So even claiming to be a man is a fallacy in a sense, because the flesh and bone, the blood, when you depart from here, gets left behind. It's things of this world. It's a thing of this world, your body. But your mind, spirit, and soul are not. So who told you that you own the name? And with ownership, only through my extensive studies do I comprehend comes liability. And remember, he who creates is master. They're the responsible party for the things they create. So, for example, things get hot and heavy, a whole lot of heat, pressure, and love create a little crotch goblin. And that little crotch goblin plays baseball one day in the street and breaks out a window. Is the crotch goblin liable for the broken window? Or is Papa, who created the little crotch goblin with a whole lot of heat, love, and pressure, responsible for the crotch goblin's destruction? Well, naturally, the mother and dad would be the liable party. Who says you own the name? When did you create the name? Furthermore, on the documentation, the name is in all capital letters. They ask you time and time again in these administrative judicial proceedings, quasi in rem at law proceedings that deal with things, if you can read English. Do you read and write and understand English? And most people say, well, yeah. They're asking you that because nothing about their document is written in English. They use Latin, they use French, they use all caps, which signifies corporations, which is really dog Latin. It's not even ASL, American Sign Language, because when you write in American Sign Language, there's hyphens in between the letters. So it's not even ASL. All right? And so the issue before the court is not to challenge the subject matter jurisdiction. It's to challenge the name. Because before you can move forward in a judicial proceeding, The law acts specific, and all things must be identified. All names must be identified. Everything must be with complete clarity. So who says I own the name? Who's the claimant here today saying that that name belongs to me and that I own it? Because the liable party is always the owner. It's really that simple. In a quasi in rem judicial or alleged purported judicial proceeding, you can't be charged with practicing law. Why? Because you're not practicing law. You're not in a true judiciary. So you're not practicing law at all. You're just there to resolve the issue before the court. Now, in the past, and I believe it to be true still to this day, that the prosecutor is responsible for bringing his checkbook, because if he can't trick you in to joining their jurisdiction and making a claim, which is a sin, it's theft by taking. You're taking something that doesn't belong to you. You come in claiming to be the name. And it's impossible to be a name. D-E-R-R-I-C-K. Derek. Derek is a sound. It's impossible for me to be a sound. I can't be the name and I can't be the sound, ladies and gentlemen. I am, for I am because I am, and I am not you. You is a debtor. You is also plural. So who's the claimant in this court today, willing to testify with first-hand perfected knowledge and independently bond their claim that I am the name? You'll see they go quiet really quick. They may even try to threaten you. Now, that's a little unbecoming of somebody who's actually administering the law, don't you think? I mean, what is the need and the necessity to threaten somebody? So let's go over a couple of threats you may encounter while asking questions. If you don't answer yes or no to being the name right now, I'm going to hold you in contempt of court. The proper response to that is, would that contempt of court be civil or criminal? Well, it's civil. Can you please produce the contract and the claimant who says I entered into contract with them with first-hand perfected knowledge, stating that I'm in breach of contract? Okay, it's criminal. Okay, can you bring forward the claimant who alleges that I have caused them harm, done them a wrong, so that I may provide remedy, who has first-hand knowledge? Because a criminal contempt means that you have caused harm, damage, or loss to a man or woman. Okay? A civil contempt means that you're in breach of contract. Who am I in breach of contract with? Well, you're in breach of contract with the state of Nebraska. Is the claimant known as Mr. and Mrs. State of Nebraska here today to testify with first-hand knowledge that I have caused them a harm, yes or no? Well, you see, sir, I represent the state of Nebraska, and so do you have first-hand knowledge? Are you bringing the claim saying that I caused harm? Well, I operate on behalf of that principal. Okay, but do you have first-hand perfected knowledge that I entered into contract with them and that I caused Mr. and Mrs. State of Nebraska harm, yes or no? Okay, well, that you just don't understand how this works. Well, that's becoming very obvious, but again, do I own the name? Who's the liable party for the name? You see, you're going to go down this rigmarole of asking questions, and they're going to keep berating you around the courtroom, trying to get you to make a claim, because once you make a claim, you're a sinner. You have engaged in theft by taking. You have no first-hand knowledge at all that that name belongs to you. Nobody's asking the proper question. Who owns the name? I've been known to use it, but I don't own it. Who owns the name? Where's the proof that I own it, that I'm the liable party for it? You'll see these administrative law clerks and administrative law judges attempt to help the prosecutor because they're all benefiting and unjustly enriching themselves due to our ignorance, ladies and gentlemen. So you come into the court as a friend, Mackenzie friend of the court, or amicus curia, all right? I'm a Mackenzie friend of the court. I'm not here to practice law. We're just here to settle this matter today honorably. I just wish to know who the claimant is. Who's making the claim? Well, you see, you've been charged with this, that, the other. Or are you not Derek S. Gonzalez? Well, I'm led to believe that the state owns the name. Could it be the state owns the name? Who owns the name? Is it the state that owns the name, or is it the United States that owns the name? I just wish to see the claimant here today, who's going to testify with first-hand perfected knowledge, independently bonding his claim, that I am the name. And I want to see the evidence before this court that he relies upon to prove that I own the name. That's how they're getting everybody, ladies and gentlemen. We're making false claims. We become sinners by doing so. We break the law by claiming something that is not ours. What evidence do you rely upon that I am the name? Can you be the name? It's just so funny. What does the claimant look like? Have you seen the claimant? What color of hair does the claimant have? All these questions, although another gentleman said last night, oh, these questions will get you thrown in jail. We'll simply ask at the beginning of the proceedings. I'm here to remain in honor. I'm here on that matter. I believe there's a mistake on the record. I'm just here to clear the record up and help this court find remedy. I believe by claiming the name that I would be engaged in perjury. If I claim the name, would I be engaged in perjury? I have no proof or evidence that I own that name. Ask it in a question. What evidence does this court rely upon that I am the name, that I own the name? Because if I own the name, I would be the liable party for the name. But I don't own Derek S. Gonzalez. I don't own the misnomer on the paper. Furthermore, you can't own anything in this world. You can't own it. It's really a beautiful thing when you think about it, because with ownership comes liability. If you don't own it and everything is vested in the state, then Title 18 subsection 8 starts to make a whole lot more sense, ladies and gentlemen. Title 18 subsection 8 says all obligations are obligations of the United States. And if all obligations are obligations of the United States, what say you, administrator? Does the United States own the name? Shouldn't the United States be the real party of interest here? Because I can't lay claim to something the United States owns. That would be theft by taking. And how dare I break the law and breach the public trust by claiming something that doesn't rightfully belong to me? In a real judicial Article 3 proceeding, this tactic would never work. And the reason it would never work is because there would be a real party and interest bringing a claim against you. There would be a real man or woman who was caused harm, damage, or loss by your actions who is bringing claim against you. That means your promissory notes. Guess who is obliged and obligated to settle those matters? Because you're the beneficiary, right? So who's obligated to take care of those matters and make sure you have everything you need? That's right, the United States. When you look at Public Law 7310, you look at Title 18, subsection 8, you look at House Joint Resolution 192, and you evaluate this, combined with Title 50, 4305B2, and you realize everything done or omitted in good faith with good conscience for good reason is not a jailable offense. I'm here before this court today in good faith, good conscience, and for good reason to resolve any issue before the court and to help this court render a proper decision. Who is the claimant making the claim that I own the name? Now remember, when they say the state of Nebraska or the state of confusion or the state of Colorado or the state of Texas, when is the last time you spoke to the state of Texas? Where do they live? When did you meet them? How long have you known them? Do you speak to them often? You see how these questions unroll and unravel their fallacy? It takes a lot of heart to do what I do. It's not easy. And it's even harder for myself to do this simple thing. It really is. Because my acquired knowledge leads me to want to chase the securities, the rights, the titles, the interest, the dividends, the derivatives of the things that they manifest utilizing the name that I've been known to use, but I don't own it. In the good book, it says, agree with thine adversary quickly. Settle your disputes in private, for the sheriff will scoop you up and the judge will surely cast you to jail. So settle the matter. I'm just here in honor to resolve the issue before the court. I believe a mistake has been made. Are you Derek S. Gonzalez? I've been known to use that name. I've been known to use it, but I'm not the owner of it. Who's the claimant claiming that I own the name and bear the liability of the name? Because I've been led to believe the United States owns the name. Is there anybody in here with evidence and proof to the contrary? Because I see no facts and evidence, and I believe none exist to the contrary. I just keep asking questions. And if I manage to make a statement in there, I end it with a question. I've been led to believe the United States owns the name. Could it be the United States owns the name? You see how I do that? Now, my brother was pointing out some other videos, and I was looking at it, and I've been looking at it all night long, just laughing, because it's so simple, it's stupid. It's so simple, it's stupid. So what do you say when they say, for the record, state your name? I don't have a name. For the record, is that an order? Are you ordering me to do something that rightfully I can't do? Because I can't own anything in this world. I've been told that it's my name. I've been known to use it, but I have no first-hand perfected knowledge that that is my name. So, to state a name on the record, would that be perjury if I have no evidence to the contrary that I own it? So when they ask you for and on the official record, state your name, I would love to state a name, but unfortunately it's hearsay. I would hate to misdirect this court and fall into dishonor. It is my intent today to remain in honor. I'm asking who the claimant is, saying that the name belongs to me and that I own that name. It's all contract, ladies and gentlemen. Contract creates the law. Equity follows the law. And unless you have first-hand perfected knowledge that you own that name, guess what? You've perjured yourself. You're a criminal. You're a sinner. You've been told, you've been led to believe that name is yours, but it is not. It does not belong to you. You do not own it. You did not create it. Furthermore, you did not create the record. Remember, he who creates is master. He who creates is owner. He who creates carries the liability. And that is the very essence of the story of Jesus Christ being put on this earth, because the Lord and the Master, the Heavenly Father, created an abomination on this earth. And equity sees that he who provides the problem must provide the remedy, ladies and gentlemen. This isn't just my works, ladies and gentlemen. I've been working with people that are very, very brilliant. Mr. Anonymous, Mark, James Bethel, David Strait. I could go on for forever and ever and ever about these brilliant people that I've worked with in the past. And they all have their little niche. They all have their little thing that they look at. Mr. Anonymous is brilliant when it comes to understanding statutory and the IRS and the commercial code and contract. He's also brilliant in a number of other ways. And he also tells me, Derek, the way that you move in a court is so brilliant that I learned from you. And I never thought there would be a day that I would have a mentor telling me that I learned from you, Derek. It blew my mind. James Bessel says the same thing. Derek, you've become so fluent, so quick on your feet, you're able to navigate the treacherous waters of commerce and come in and out of jurisdictions so fluently that it just amazes me how quick you are. But none of that was possible without the Heavenly Father. None of that was possible without each and every one of you asking sound questions, seeking the truth, the light, the way. If you just stand in the light with honor and integrity, you don't get excited, you don't get upset, you fill the courtroom with love. Your intent is to help your fellow brothers and sisters resolve their issues. When you go in there and claim something that isn't yours, that you believe to be yours, you're a bold-faced liar. You're a bold-faced liar, and you yourself are now the claimant. You see, because there is no claimant in that court when it's the state of Nebraska versus the United States property. There is no surety. Who's the claimant that is the surety of this matter before this court today? Has anybody seen the claimant make a general appearance with sworn testimony under the pains and penalties of perjury, indemnifying I if they falsify a record? Are you or are you not Derek S. Gonzalez? I'm led to believe the United States owns the name. I use the name. Well, if you're not Derek S. Gonzalez, we're going to issue a warrant. Well, I just told you that I've been known to use the name. I'm asking who the liable party for the name is. Who's the owner of it? I'm not the owner. Oh, I screwed up. I don't want to make a statement. Say I screwed up. When I say I am not the owner, now they go, okay, great, prove it. Prove that you're not the owner. You made a statement. You made a claim. You're now a claimant. Thank God. Prosecutor, he almost had you by the balls. Excuse me, I'd like to redact that last statement from the record and ask it in the form of a question. Who's the owner of the name? Where is the claimant making the claim that I am that name? Who has first-hand perfected knowledge that I am that name? Do you live at 1907 South Street? Is it possible to live at 1907 South Street? Or could it be that I live within myself, Your Honor? Where do you sleep? I sleep within myself, Your Honor. Where do you reside? I reside within myself, Your Honor. Could it be that I reside within myself? Could it be that I sleep within myself? Could it be that I don't have a residence? Could it be? Do you have a driver's license? Could it be that that's the state's property? Could it be they own the name? Could it be the United States carries the full liability of the name? What evidence does this court rely on that I'm a resident? What evidence does this court rely on that I own the name? It's all about the name, guys. It's all about the name. And who the claimant is making the claim. Now, you may run into an administrative law judge in a quasi-in rem proceeding dealing with things, trying to get you to contract and be the claimant so your ass can set as surety as an asset, your assets in jail. All right? Because you made a claim. It's so simple, it's stupid. Now, guess who's on the hook at the end of the day if you won't claim the name? Just guess. That's right, the prosecutor. Do you think the administrative law judge is going to take liability for somebody else's incompetence? They were gambling. They were betting that you didn't understand the nature of the game. That's why you have a right to be informed of the nature and the cause of the action. The nature is they are looking for a claimant. That's the nature. It's a contract court. Con, that puts you on a track to set as an asset, in jail as a surety, while the bonds and securities mature, and they put everything in escrow. But you see, if you're there in honor to remedy the situation, to find out who the claimant is, so that you can resolve any matter before the court. It takes two parties in a court to create controversy. They're using your own statements against you, and that's what creates the controversy. Through the public fool indoctrination system, we've all been led down the wrong path to make claims. And claims are horrible. First of all, I can tell you that the sky is blue. That's a piss poor claim. You want to know why? Because a colorblind man will argue all day long that it's a light shade of gray. Who's right and who's wrong? There are times when the sun sets that it may be orange. So for me to say that the sky is blue is complete asinine bullshit. Because their perception of the way they see it versus my perception of the way I see it are two different things, which create controversy, which gives an administrative law judge the ability to rule however the hell he feels. You're granting them jurisdiction by making claims. Do not make a claim and watch how quickly your court case disappears. And I say your court case, and it's not even your court case. It's the United States court case, because they carry the liability. They own the name. The judiciary is operating under the executive branch in quasi-judicial proceedings, absent having original jurisdiction, which would be the federal one Supreme Court having superior jurisdiction, a competent jurisdiction, where you are indicted under federal indictment, or two witnesses and a victim make statements that are the same, proving that you have caused harm, damage, or loss to somebody, and those people will substantiate their claim in court. Well, that's an interesting question. Is the police officer the process server, or is the police officer the witness, or is the police officer the claimant? Because he can't fill multiple roles in the court. So if he's the process server, then they don't have a witness. And if he's the witness, then you were denied due process of law. But why even argue those semantics when it all really boils down to who owns the name? Who's the liable party for the name? See, I had recently been asked, I was recently jailed in Indiana, and I was asked, what's your birth date? And I said, well, I can't tell you that. I'd be lying. He goes, no, you don't know your birth date? I said, of course I don't know my birth date. He says, well, what do you mean? I says, what, you think I came out of a vagina, looked at my watch, and was like, well, it's 10:30 on a Friday on June 10th, 1984? That's hearsay. It's a lie. I can't prove that. I'm not about to perjure myself and tell you that I know a date. I've heard there was a date, but I don't know it with firsthand perfected knowledge. I wasn't cognizant at that point in time in my life to comprehend a calendar year or a date and a time or read the clock on the wall. He quickly says, well, I know my birth date. And I said, and you're a fucking liar. How you like them apples? You're a fucking liar. You have no first-hand perfected knowledge of that at all. And if we go to court and you say that shit, I'll prove beyond a reasonable doubt that you're a fucking incompetent idiot. That's right. Can they cast you to jail for not knowing something? Don't you have a right to a fair and meaningful hearing? Don't you have a right to be fully informed of all aspects of the claim, including knowing who the accuser is and what evidence they have against you? So why not just ask questions? Well, how do you plea? I would like to plea, but I have some questions first before I plea. If you don't mind, I need some clarity. Because a contract binds no one without full disclosure, correct? I was too new to know. That's right. You're that of an infant, a ward of your mother and your dad, gifted to you by the Heavenly Father. When Pontius Pilate asked, are you not the Son of God? Jesus said, if thou believest so, who am I to tell you otherwise? But what evidence do you rely upon to make such a bold statement? That's why in the Bible it says, woe unto you lawyers, for you lay men with burdens grievous to be borne, yet ye yourself not even touch them with one finger, because they're not about to make a claim, ladies and gentlemen. They say that they're operating on behalf of the state. When's the last time you spoke to your friend known as the state? Mr. and Mrs. State. Paul, you know how this works. No, I don't. I don't, and that's why I'm asking these questions. What evidence? Well, okay, instead of making a statement, when they say, you know how this works, what evidence do you rely on that I comprehend how this works? What evidence? You ask a question, you don't make a statement. Well, you know what dollars are. What evidence do you rely on that I know what dollars are. He who makes the statement bears the burden of proof. You're making all these statements. Are you the claimant? Are you the surety? Are you the one liable? I'm hoping this is helping you guys out. What evidence do you rely upon that I owe child support? I'm led to believe that the entity, the name, may owe the child support, but I'm also led to believe that the United States carries the burden of all obligations. Could it be the United States is the one you're looking for? Because suits can only be brought forward with like entities. It's either man on man or entity on entity. What evidence does this court rely on that I'm the owner of said entity and primarily liable for it? I'm led to believe the President of the United States is liable to pay all obligations and debts. He's primarily liable because I'm led to believe all property is vested in the President of the United States. I'm led to believe that they're administering the largest bankruptcy the world has ever seen. Could it be? If you continue to ask questions and you never make a statement and you make it through all their ilk and their false threats, you'll walk out of there free. The second you claim that name, your goose is cooked. It's cooked. Now, there was a man, his name will come to me shortly, who was in federal court because he was in Washington, D.C. with a pistol under his seat that he had forgotten about. And Rod Class was his name. The man is brilliant when it comes to statutes, codes, city ordinances, rules, regulations, constitution. He's just absolutely brilliant. He ended up winning his case. And as the judge left the room, the lawyer, the plaintiff, the prosecutor turned and looked at him and said, "You may have won this case, but you're still a sinner and you're still broke the law." Now, until recently, I didn't understand what that lawyer was talking about, but I get it now. You see, Rod Class claimed the name, ladies and gentlemen, and although his arguments were superb and the administrative law judge saw it in his favor, he still was a sinner. He still took something that doesn't rightfully belong to him. And that's why that lawyer told him that. You may have prevailed in this case, but you're still a criminal. He was using something that doesn't belong to him. And that lawyer was being oh so polite to point that out. Whether or not Rod Class will ever figure that out, I do not know. But I will tell you this much, that lawyer did not lie to Rod Class. He may have been vague and ambiguous in what he was saying, but he made a very poignant point if you understand what I'm communicating to you today. And in Article 3, Subsection 2, Subpart 1 Court is where you will find a chancellor in ecclesiastical law that is charged with the duties of administering the grace of the Heavenly Father. That's where you will find that. And these lower incompetent courts quasi in rem at law judicial proceedings, ladies and gentlemen. It is all about contract and consent. If you don't make any statements, they have no claimant. They have no cause of action. It falls on its face for want of prosecution because there is no claimant. The state is an inanimate object. It's a fiction of man's imagination. No different than Santa Claus, the Tooth Fairy, Tinker Bell, Pinocchio. They're all fictions. And if you're gullible enough to believe that the state, who you can't face, you can't question, is bringing a claim against a name that you believe you own, well, then your ass is going to sit in jail. That's a guarantee. When they can't qualify what they mean by dollars, ladies and gentlemen, they've created an impossibility, and you are not expected to perform impossibilities. They take you up 100 feet in the air and say, jump or die. Well, they're basically saying you're going to die either way because it's an impossibility for you to fly. And because you can't fly and they've created an impossibility, you have a rite of passage to walk back down the stairs. Unharmed, unimpeded. So long as you don't make a claim. You ask questions. I believe there's an impossibility presented before this court today. Could it be without an accuser, there is no claimant? Who's got first-hand perfected knowledge here today before this court that I am the name and that I am the owner of the name? The name on the paper is never yours. It's not even spelled correctly. It's a false and fictitious misnomer. That's why they ask you if you can read and write English. It's like a negative averment almost. Can you read and write English? Yes. Good. Well, you're still standing here, and you're not asking questions. You're making statements. So obviously you understand what this court is. This is a quasi in rem at law judicial proceeding to create contract.